Hello, everyone. Thank you for having me here. I appreciate it. Glad to be here to talk to you. Am I speaking in the mic okay? You can hear me fine? All right, great. So I guess the first thing you wanted me to talk about is the difference between elder law and estate planning. Everyone needs to do some estate planning. Everyone has their stuff that, unless you cleaned it out with your Swedish death cleaning, there's going to be some stuff left. So you need a will or maybe a trust to leave those assets behind and to say who gets those assets when you're gone. So that's always important. But the other aspect of planning is what we call elder law planning. Now, some things overlap. As part of your estate planning or your parents' estate planning, everyone should have a power of attorney and an advanced health care directive, or power of attorney for health care, as New Hampshire calls it. A lot of states call it a health care proxy. A lot of people call it a living will. I don't like that term. It's sort of a misnomer, but lots of people use the term living will, so it's fine to use that. What a power of attorney for health care or a living will or health care proxy is a document that names someone to make medical decisions for you if you cannot. Really, really important. Obviously, if you're awake and conscious and the doctor suggests you have a surgery or something, it's your choice. You can have the surgery or you can say no to the surgery, and you'll make that choice yourself. But if you're unconscious or mentally unable to make an appropriate decision, no one can make that decision for you unless you've granted them that authority on a piece of paper that says, I appoint my daughter, my son, someone, and I give them the authority to make medical decisions for me. Now, that what I just said is not quite 100% right. New Hampshire did change the law a few years ago. We do have a medical surrogacy law. If you don't have a written health care directive, certain people in certain priority can make medical decisions for you, at least temporarily. I think if it's a life or death thing, you still might have to go to court to do a guardianship. Someone was talking about guardianship earlier. It's important. The legal documents are really, really, really important. If you have the legal documents in place, your family's going to be able to take care of things without having to go to court, without having to deal with judges or other people or paperwork or a court hearing that's 3 or 4 or 5 weeks from now. Everyone needs to get their pieces of paper, their legal documents in place. So the health care directive or power of attorney for health care is vitally important. The financial power of attorney, it's called power of attorney, but we call it, to differentiate, I say financial power of attorney. That's the legal document that will allow someone to do your other everyday business for you. Obviously, if you're awake and conscious and healthy, you write checks to pay bills, or you go online and you electronically pay the bills. You sign a contract with the electric company or your cell phone company. You do all your financial and personal business yourself. But if you can't, again, if you're sick in the hospital, in a medical facility, or just mentally unable to do it yourself, no one can just step in and do stuff for you unless you've granted them that authority. So you need that power of attorney. So will is important, power of attorney, health care directive, or power of attorney for health care. Those are the 3 vital planning tools that everyone should have. So then what's the difference with elder law? Well, elder law does focus on the issues of planning for aging. At least the legal aspects of that. We've talked a lot today, or heard a lot today, about planning for aging. I talk to my clients about a lot of those issues that I already heard this morning, thinking ahead about caregiving and cleaning out the house and organizing your stuff, making things easier for your family to deal with things. But elder law focuses on what is the major problem for most people, is the cost of elder care. What I say to people is, we have no system for taking care of the elderly in America. We're a capitalist system, so we're a pretty much pay-as-you-go society. There is no organized system of dealing with people as they age. Everyone deals with it in their own way and stumble through it as they figure it out, as we've heard from some of the other speakers today. And you'll have to figure that out for yourself or for your family members as well. Again, the big problem is, though, there is no way to pay for elder care. We don't have any kind of government system that's going to automatically step in and pay for elder care. Medicare is health insurance. It pays for medically necessary care. If you go to the hospital or your doctor, you have surgery, that's medically necessary care, and Medicare or whatever health insurance you have is probably going to pay for it. Maybe there'll be some co-pays, but they'll cover it. But Medicare, as health insurance, does not pay for care that is not medical. So if you need a home health aide to come into the house, you need to come to an adult day program like they do here. You need to move to an assisted living community, or you need to go to a nursing home for long-term care. None of that's covered by your Medicare. You're going to have to pay for all of those things yourself. That's the way we do things. You have to pay for it yourself. So that's part of the planning. You need to think, how in the heck am I going to pay for it? Do I have the money to pay for it? As part of your financial and retirement planning, you might need to allocate a huge chunk of money to your elder care as you age. The last article I read said $125,000, but I think that was pretty old. I'd be willing to bet it's closer to $200,000 or even $300,000 is the average expenditure that American will spend on their long-term care in the last 4, 5, 6, 7 years of their life. Now that's just a number, you know, it doesn't mean anything. And some people will drop dead of a heart attack and spend nothing on long-term care. Other people will get early dementia and potentially spend millions on their care if they have the millions to spend. And that brings me to the point of most people. What happens if I run out of money? We do have one social safety net, and that is the Medicaid program. Our members of Congress very cleverly created Medicare, and then they created the corresponding program that they called Medicaid. I wish they hadn't named them those two things. It's really annoying. So easy to say it wrong. Everyone says it wrong. I've said it wrong. Medicare is your health insurance. Medicaid is health insurance for a lot of people. It does provide regular health insurance for younger, disabled, mostly disabled people who can't otherwise get health insurance. With the Affordable Care Act, a lot of people can get health insurance in other ways other than Medicaid, but it's a major program that provides health insurance for a lot of people. A component of Medicaid is that it does pay for some of that care that I mentioned that Medicare won't pay for. It can pay for home health aides. It can pay, well, generally won't pay for assisted living, but it can pay for nursing home care. But it is a social safety net, a means-tested benefit program, a welfare program for the poor, if you will. And you have to financially qualify for Medicaid in order to be eligible. I heard people mention the 5-year look-back program, 5-year look-back rule. You have to be financially eligible for Medicaid, so you have to have a small enough amount of assets. It's $2,500. That's a terribly small amount of assets. And so you virtually have to be broke before Medicaid's going to be paying for your care. Another major rule of Medicaid is this 5-year look-back rule, because they look at your finances for the 5 years leading up. You apply for Medicaid November 1st of 2025. They're going to go back to November 1st of 2020 and look at all of your finances, all your bank statements, and see what you did with your money. Someone mentioned earlier this morning, you're always entitled to spend your money on yourself. No one can tell you not to spend your money on yourself. If you want, steak dinners or lobster dinners, you can do that. You don't have to eat tuna fish, which is probably just as expensive anyway. But what you can't do and qualify for Medicaid is give any money or assets away within that 5-year look-back period. If you gave away, someone this morning mentioned you paid for your granddaughter's college, or you took the family on a trip and paid for the trip, or you bought your grandson a car or something like that. Any of those things, if they happened within 5 years of you applying for Medicaid, you're going to at least temporarily be disqualified from getting Medicaid because you made what they called uncompensated transfers or gifts. So as people age, it's something to think about. If they were making gifts or they routinely did make gifts, maybe at a certain point in life they need to stop making those gifts. I mean, the whole point of the Medicaid program is that you're supposed to use your own money to take care of yourself. if you run out of money, yes, we've got this backup called Medicaid, but you're not supposed to, willy-nilly give your money away to your family and then come to the government and say, oh, I'm poor, I need government benefits. That's the thought process behind the look-back rule in the Medicaid program. You have to be financially eligible and you cannot be artificially eligible. Except, yes, they made this 5-year rule. So yes, you can be artificially eligible if you do it within the thought process of the 5-year rule. And that is something I, as an elder law attorney, do. I talk to my clients, we look at their financial situation, I ask them, if they want to give away assets, because you've got to want to give away assets, but some people are very adamant about preserving their home or maybe their camp or something like that as an inheritance for their children, and they don't want to be forced in their last 3 or 4 years of life to sell that asset and spend it on their care. So they are willing to sometimes give it away, and that's what we can do in the context of elder law or Medicaid planning, is take an asset that belongs to someone, either put it into an irrevocable trust or outright give it away to their children or grandchildren. In some way, the elder gives the asset away, and as long as they don't need to apply for Medicaid in the next 5 years, that's okay. If they apply for Medicaid outside the 5-year look-back, more than 5 years later, the fact that they gave something away more than 5 years ago will not disqualify them from getting Medicaid. So it's a planning tool we use sometimes, and it needs a lot of thought. Some people come to me and say, oh, I want an irrevocable trust, and we talk about it, and in the end they decide they don't want that once they learn all the details of it. You are literally giving an asset away. If it's your home, it could be worth $400,000, $500,000, $600,000, $700,000. That's a lot of money to give away. That money could pay for a lot of care for yourself. You might want to have that money to pay for your care or that value. And who are you giving it away for? That's the other thing. People come to me and say, I want to protect my assets. And I always say, who are you protecting them for? And sometimes they have an answer, sometimes they don't. But the general rule is that if you are protecting assets, you're doing it for the next generation, the children or grandchildren. You're giving an asset away that belongs to you in order to protect it for someone else. And you have to decide if that's the right thing for you or not. Sometimes it is, sometimes it isn't. So that's kind of Medicaid planning in a nutshell. I'm looking at my notes to see what we talked about. We talked about the PPA and the MMMNA. Those are some terms. Everything we do is full of jargon, isn't it? And the elder care area is no different. There's doctors' jargon, there's lawyers' jargon, there's medical people, caregivers' jargon. They know programs by an acronym or something like that. I guess a little bit more about Medicaid will answer these questions. If and when someone is on Medicaid, what's the PPA? Oh, the patient paid amount. That's what the PPA is. Well, when someone's on Medicaid, they do have to use part of their own money to pay for their care. If they're in a nursing home and they get some income, which most everyone does, they get Social Security or something, if they're eligible for Medicaid, they still have to use their income to pay the nursing home, and Medicaid pays the rest of the bill, and that's called the patient paid amount. It's usually almost all their income minus a personal needs allowance and some allowable deductions like health insurance. Then this other note I wrote down, the MMMNA, the minimum monthly maintenance needs allowance. That's for spouses. So let me talk about that. Spouses have a certain level of protection under the Medicaid program. Again, people always come to me and say, oh, I don't want to lose my house to the nursing home. What if my husband goes in the nursing home and they take our house away? That's not going to happen. With a married couple, there are protections for the spouse who's still at home. We call them the community spouse, or the rules call them the community spouse. If your spouse goes into a nursing home and you do find them eligible for Medicaid, the Medicaid rules are not touching your house. Your house is absolutely safe for you as the community spouse still living there. No one's taking it away from you. No one's touching your house. Even if your spouse dies, and even when you die, they're not coming after the house. They can't do that. If you are a community spouse and your spouse went into a nursing home and went on Medicaid and then passed away, the Medicaid office has zero claim on your house. They're not coming after it now. They're not coming after it after you die. Now, of course, if the community spouse eventually goes in the nursing home herself, well, then yes, Medicaid might have a claim on the house. But most people, at least while they're alive and they're not losing their house. No one's taking their house away. So if your spouse went into a nursing home and you're at home, the community spouse, you're going to be able to keep your house, and you're going to be able to keep a certain level of assets. That's what's called the Community Spouse Resource Allowance. It's a number set by law that's indexed to inflation. It changes every year. I usually have it memorized by the end of the year when it's about to change. It's $157,920 in 2025. That's going to be different January 1st, and I'll have to memorize a new number. That's the amount the community spouse is allowed to keep of the couple's assets. So again, a simple example, in the rules say a married couple there's a married couple, one goes into the nursing home, one's still at home. The one at home gets to keep the house, but then say they have $300,000 of investments, money in the bank, things like that. The rule is that the spouse at home can keep half of those assets up to that $157,920 limit. So with this couple that has $300,000, the spouse at home will be able to keep $150,000, but the other $150,000 is going to have to be spent on something before the one in the nursing home qualifies for Medicaid. I guess we were talking about the spend down and things like that before too. I heard some mention of that. What can you spend your money on? Anything you want to spend it on, as long as you spend it on yourself or your spouse. Sometimes you can fix up the house, put on a new roof, do a new furnace. Sometimes you can buy a new car for the spouse who's still at home. Prepaid funerals is something we always suggest. Two prepaid funerals can be purchased for both spouses. Sometimes you have to spend some of that money on the nursing home because you're busy spending down, and there is a nursing home bill that has to be paid. Hypothetical couple that add $300,000, once they get down to $150,000, the one in the nursing home should qualify for Medicaid. The one at home keeps the house and the $150,000, and the one in the nursing home does have to pay some of his or her income to the nursing home. But this minimum monthly maintenance needs allowance that's in my notes, if the spouse at home doesn't have that much income, he or she can keep some of the income of the nursing home spouse in order to bring up to the monthly maintenance needs allowance. And I didn't write down what that number is, and I don't have that number memorized. I think it's somewhere around $2,500, something like that. That's also a number that changes every year on January 1st. So it's something you have to look up when the time comes. So how am I doing on time? I'm only a quarter way through my notes. Oh, there's a clock right there, 12:30. My notes talk about legal costs. If you need legal services, that's also something in America you pretty much have to pay for. I run my own business. I got to charge for my time. That's what I do. I sell my services. There are some free and low-cost services that are out there. If you do need a lawyer, you can contact the New Hampshire Bar Association. They have a lawyer referral service that can find you a lawyer at regular price. Usually they have a reduced fee service where they can find you a lawyer who's willing to do services for a reduced fee. They do have a pro bono program where they can find lawyers for you that will provide services for free. I think you have to financially qualify for the pro bono program. New Hampshire Legal Assistance, what are they called now? 603 Legal Aid, I think. They provide, they do have a senior citizens project where they can do some elder law services, probably for people who financially qualify, but they can provide you some services. A big thing I heard this morning is talking about what's out there, what can I get, what is out there. There are other programs, things I don't know about. You've got to ask. You've got to find the professionals. Your lawyer may know some things but won't know everything. People here working at a place like this may know some things. Service Link is a good choice. The senior centers in your town, nursing homes and hospitals have social workers that may have specialized knowledge. There's always something new out there. VA benefits. New Hampshire has a veterans assistance I didn't bring that information. I don't think I wrote it down, but there is a veterans office in New Hampshire which is staffed by veterans, and they're there for anyone who is a veteran to get various help and assistance. And they know a lot about the various odd programs that are out there. There's always something new and different. You know, there's always a grant here or a donation there or some temporary program here or there. So you got to ask around for what there might be out there to help you out already. But someone was talking this morning about doing a guardianship for someone. In today's world, you should never have to do a guardianship. What is guardianship about? Well, again, you're your own person, you make your own decisions, you take care of your own affairs. If something went wrong and you couldn't take care of your own affairs, and you hadn't appointed someone and given them the authority to do it for you, the only way to get that authority is through the court process of guardianship. Someone has to petition the court, there's going to be a hearing, they'll probably appoint a lawyer to represent the potential ward, and it's a very protective process. We're independent people here in America. We like to be in charge of our own lives, and we don't like our freedom and independence taken away. And in New Hampshire, we treat that very strongly as well. The standard of evidence in a guardianship is beyond a reasonable doubt, the same thing that we do in criminal proceedings. The judge in the court has to be convinced that you must need a guardianship and there's no other way to deal with things. And you have to have enough proof to show that that's the case. Recent incidences of injuries or problems that went wrong and evidence from a doctor or at least medical records that show the person is really in need of a guardianship. Yeah, the judges will help people out most of the time, but we do have this high level of standard to prove the need for a guardianship, because a guardianship does take away the rights of the individual to make certain decisions and vest them in the hands of the guardian. That's a horrible thing, to have your right and ability to do things put in the hands of someone else. That's why I recommend powers of attorney and healthcare directives, because you're not giving up any power and authority when you sign a power of attorney. You are hiring, maybe for free, you're giving an agent some power to do things for you, but you retain that power to do it yourself too. You can keep doing your own things as long as you can. Only when you can't do you expect your agent to step in and do things. And if your agent was doing something and you didn't want to do them, you could stop them if you've got the capability. You can tell them, no, don't do that. You can tell them, you know, you're fired. You're no longer my agent. I revoke my power of attorney. So you retain control with your own power of attorney and can change it any time in the future, fire that agent if you don't like that agent, and you don't give up any of your own personal rights. With a guardianship, they do take at least some of those rights away from the ward and vest them in the guardian. So you don't want to do a guardianship. You need to have a power of attorney, financial power of attorney, and a power of attorney for health care in place so that your family won't have to do a guardianship and you will not have some of your rights and privileges taken away from you. Healthcare directives, the power of attorney for healthcare. An attorney can do that for you. You don't need an attorney. You can find forms online. Foundation for Healthy Communities, healthynh.org. They have the standard healthcare directive. It's a nice booklet. The healthcare directive is in there, but the booklet also walks you through all sorts of thoughts to think about medical decision making, especially end-of-life decision making. So a great thing to do. You can download that packet, print it out, fill out the healthcare directive. It does either have to be witnessed by two disinterested witnesses, not your children, not your brother or sister, not your spouse, not someone you named in the healthcare directive, but some disinterested third parties, or it can be witnessed by a notary or a justice of the peace.
Is that in the literature, the website you just talked about?
I may not have put it in the literature. healthynh.org. H-E. There you go. Everyone should have a healthcare directive in place.
18 and over.
Right.
Everybody.
Sure, 18 and over. Can't do that when you're a kid because your parents make your medical decisions for you when you're under 18. I know. Someone this morning talked about the POLST, Physician's Orders for Life-Sustaining Treatments. I think some people are calling them medical orders for life-sustaining treatments now. I don't know. It's in Massachusetts calls it MOLST, yeah. People always ask me, oh, can I get a DNR? I go, I don't do DNRs. That's something your doctor does. What is a DNR? It's a do not resuscitate order. It's saying to your medical professionals, let me die if I have a heart attack. Well, you don't really want that. Most of us don't want that. But there are some people who are in a certain medical situation where maybe dying of a heart attack isn't the worst of things that could happen to them. So maybe they don't want to be resuscitated if they do have a heart attack. So DNR orders, do not resuscitate orders, have been around for years. They're created by your doctor. They're usually signed by you and your doctor. And, you know, sometimes they're on a pink piece of paper. You put them on your refrigerator at home or something. You got to plan for that sort of thing and think about it. But it's for someone who's already probably dying of some medical condition. And again, dying of a heart attack might be a blessing as compared to finishing out the course of whatever else is working on them. But that DNR is kind of limited. So the medical professionals did come up with this new protocol called the POLST, Physician's Orders for Life-Sustaining Treatment. It's a do not resuscitate order plus. It's an enhanced order because it contains all sorts of other options like breathing, intubation, artificial feeding and nutrition, hospitalization or not, dialysis or not. So you can make decisions on this form signed by the patient and the doctor, and it's usually a pink piece of paper that can travel with you to different medical facilities, and it can tell the medical professionals what you want. And again, those things might change as the course of whatever medical condition you have progresses. You don't want one if you're healthy again. But if you've got a medical condition, especially a chronic or terminal condition, you probably do want a POLST, so you have that in place to tell doctors what you want. You still got to have that healthcare directive because there may be a time when a decision has to be made and no one's sure. And if you've got a living human being who's named as your healthcare agent, then they will be able to make that decision for you. And that's something I want to talk about too that I always mention is that doctors do not make medical decisions. Patients make the medical decisions. Each and every one of us is in charge of our own body. No one gets to do anything medical to our body without our permission. We can always refuse any medical treatment. The doctor suggests the medical treatment, and most of the time we say, okay, if that's what the doctor thinks, then I'll say yes to it. But you're always free to say no to it. Usually you'll say yes most of your life, but if you do have a terminal or other chronic condition, there might come the point in time when you start saying no, and that's when you need the ability to say no, or you need that healthcare agent standing by who knows what you want and how you feel and will make that medical decision for you. And tell the doctor no if that's what you want. What you're doing, don't do Medicaid planning without an attorney to help you. I've read all sorts of things. I've heard all sorts of stories. The Medicaid rules change over time. Now, they haven't changed substantially in 25 years. They last changed in a major way in 2004, so it's been more than 25 years since they've changed. But some people still hear stories, oh, my grandmother did this. Well, yeah, if it was before 2004, there were things we could do under the Medicaid rules that they did away with with those 2004 changes. So you can't rely on what someone else said they did or I heard you could do this. You need to talk to a professional and make sure they tell you what the Medicaid rules are today and what's going to work for you today. Again, the look back and that financial information. If and when you're going to the government and saying, I want Medicaid benefits for me or my loved one, they're going to say, is this person financially eligible? And prove to us this person is financially eligible. That's a very difficult thing to prove that someone's financially eligible for Medicaid. They got to have few enough assets, and then you got to give the government 5 years worth of all of that person's financial records, and you need to go through those records and find anything that looks weird and be able to explain it to the government. The government can, the DHHS, the Medicaid office, can They have the power to grant Medicaid benefits or deny Medicaid benefits. And if they're not convinced that you need or are eligible, they will just deny your benefits, and you have to prove otherwise. So if there's, you know, a $5,000 cash withdrawal on your checking account 3.5 years ago, you're going to need to tell Medicaid where that $5,000 went, and not just tell them. You've got to have some receipts or proof of where that $5,000 went. I guess we were planning for the meeting. There's all sorts of weird things now, like Venmos and other methods of moving money around. You're going to have to prove that. I see a question?
Yes. If you go through the 5-year look back, and now you have Medicaid, do they do that every year that you have Medicaid? You have to like reapply for that 5-year, or if it's been 10 years since you did the 5-year look back, can you spend money and not tell Medicaid?
Well, if you're on Medicaid,
is that a thing you have to do every year?
they do revaluations to be sure you haven't gone over the asset limit. Most people who are in a nursing home don't go back over the asset limit. They can't, but because they're paying all their income to the nursing home. Their spouse at home can go over the asset limit. That's fine. But the person on Medicaid does have to keep telling Medicaid that, yes, we're eligible still. I'm going to take my house away. I said no, but and they won't. They don't come take your house away. But for some people who are on Medicaid, they're allowed to keep their house. Once they die, then DHHS says, okay, they were on Medicaid for 3 years. We spent $297,000 on their care, and you got that $500,000 house. Pay us back. Now, they're not taking the house. They just want $297,000. How are you going to get it other than selling the house? But if the house is worth $5 and they are owed $297, I guess there's 100 and whatever the math is. There's something left over for the kids. But that's when they get the house, is when someone dies who was on Medicaid, there's no spouse left, and they were allowed to keep a house. Then yes, usually the house has to be sold because Medicaid has to be paid back. Yeah, there's a couple other people that could keep a house. A child under 18, which is pretty rare because most elderly people who need Medicaid don't have children under 18. A sibling who has an ownership interest in the house is one of them. Spouse is obviously one. I don't know that there's anyone else. There are some exceptions in the Medicaid rules. Again, I said the general Medicaid rules, you can't give any assets away within 5 years of applying for Medicaid, or you'll be disqualified from getting Medicaid. There are a couple exceptions to that. Spouse is the obvious exception. You can move assets to your spouse at any time. So sometimes we do that. If a husband and wife, one of them's going in a nursing home, we sometimes have the one heading into the nursing home deed the house 100% to the spouse. Then maybe later the spouse can do something with the house if they want to. A disabled child is another exception in the Medicaid rules. At any time, even within the 5-year look back, you can give assets to a disabled child. Outright or in trust, depending on the situation. It might make sense to do it one way or another. Any other person with a disability, you can transfer assets to a trust for that person with a disability, and it doesn't disqualify the elder from getting Medicaid. So sometimes grandparents will have a disabled grandchild, and we are allowed to transfer assets into a trust for the disabled grandchild, and the elder can still qualify for Medicaid, even if that happened within 5 years. Yes? Yes. A husband and wife are treated as one economic unit when one of them is applying for Medicaid. So, yeah, there's sometimes reasons to move assets back and forth between the two, and that's why it doesn't count as a transfer, because the husband and wife are treated as one economic unit when one is applying for Medicaid. So, yes, they look at everything. It doesn't matter if it's his, hers, or theirs. It's part of the eligibility determination for Medicaid. Now, once the one goes on Medicaid, then they are two separate financial entities. The one at home keeps the house, and they're $150,000 or $157,920, and now they're not applying for Medicaid, so those assets are irrelevant. I mean, people say, well, what if I kept my $157,000 and it's in the stock market and it grows over time? That's okay, because they do not look at the spouse after the one is eligible on Medicaid. They only look at the Medicaid person at that point in time. But during the initial eligibility phase, yes, they look at the assets of both husband and wife. So, yeah, you can't hide assets by transferring them to your spouse, but depends on what it is you might want to transfer. Well, like the house is the one thing that we usually put in the healthy spouse's name. I see lots of questions. I'm fully able and ready to take questions. Yes? You can always transfer the ownership of the house anytime in a way that makes sense to the family, but a transfer to children is generally going to be a disqualifying transfer for Medicaid eligibility. So if you're about to or will within the next 5 years, one of those people is going to apply for Medicaid, then you probably shouldn't do that. Again, each situation is different. Maybe a child has a disability and you can transfer it to them. I mean, it's sort of a cheat in the rules, but it's allowed under the rules. We've done it. I've done it for clients. You know, someone's heading in a nursing home, a widow, she's got a house and a few dollars, but one of her children is disabled. We transfer all the assets to that disabled child. The woman qualifies for Medicaid right away. Once they're in the hands of the disabled child can do anything he or she wants with them. So if he wants to now split the money with the siblings, he can. It's allowed. The initial transfer was allowed, so what happens after that is irrelevant to the Medicaid eligibility. I'd say it's kind of a cheat, but it's something we can do. The Medicaid office is always looking for things that we do and then try to make them against the rules. So don't tell anyone. We did. You know, the things elder law attorneys do, the government knows. And they don't like that we do it, but they set up the rules. We're lawyers. We figure out the rules. We figure out ways around the rules. You're allowed to figure out ways around the rules. You're not, I mean, you're bound by the rules, but if there's a way around the rules, you're allowed to use it. It's not a cheat. It's using the rules as they're written. So, and that's why I say go see an elder law attorney if you can and need to, because they know the rules and they know the ways around them, and it's not cheating. It's something you're allowed to do. If they want to change the rules and say we can't do it anymore, then we can't. But if they've written the rules a certain way and they wrote that 5-year look-back rule, we can play with that rule because they gave it to us. And we're allowed to. It's not cheating. And what I said was sort of cheating. It's not cheating. It's allowed. And that's the stuff we've built up over the last 100 or so years. It's not a system at all. We just work with what we have, what they've given. There's a government program called Medicaid. It exists, but we got to work with the rules of that program. There are other programs that don't, there are things that don't exist, and you just have to do what you have to do to make it work. Yes, you can get divorced. A person goes into a nursing home. Yes, the other spouse gets, or the ex-spouse gets to keep her assets. But again, it's something you can do. Yes, you can do it, but it has to work financially. If you have a prenuptial agreement and you don't get divorced, it's meaningless as far as Medicaid is concerned, because you're just a husband and wife and they treat your assets as they do. Generally, yes, that's the system we have, is if someone needs care, they need to go to a nursing home and it's $10,000 a month, and the husband and wife have $500,000 of investments or assets, yeah, they got to spend a large chunk of that money on the nursing home. All right, so you brought up another exception to the rules. If a child is living in the parent's house, if the parent goes into a nursing home, they'll generally allow the family to keep the house. But after the elder dies, they might be the estate recovery. There is another exception in the Medicaid rules. We commonly call it the caretaker child exception. If a child moved into the house of a parent and for 2 or more years took care of the parent, and their care of that parent kept them out of a nursing home, then as part of the Medicaid process, the parent could give the house to that child right then and there. They need to give it to them while they're still alive, and it's not a disqualifying transfer. The trouble is proving that to the Medicaid office. Did you really, keep them out of a nursing home? It's hard to build that kind of evidence. No one knows this rule exists, so no one works to be building up the evidence to show it exists unless they went to an elder law attorney old enough or early enough to get this information. This caretaker child rule exists. You need to build the evidence. You got to get doctors saying, oh, your mom should be in a nursing home, and put that down in writing. she needs this kind of care and that kind of care and that kind of care. And then you document that you provided this kind of care, that kind of care, and that kind of care at home for her and kept her out of the nursing home for 2 or 3 or 4 years. And then mom can transfer the house to the caretaker child, and it's not a disqualifying transfer. But people willy-nilly. So someone mentioned, families meld their money and their assets together a lot. Because that's what people do. There's nothing wrong with that. You got a joint account with your mom. Okay. She opened it when you were 12. You still have it. There's mostly your money in it, not mom's money. Medicaid doesn't care. If mom's money isn't on that bank account, that's mom's money, Medicaid rules are going to say. People own a house together, or they live in the same house. Someone's name is on the deed. They don't care. It doesn't matter. Well, it does matter if and when you're going to the government and asking them for government benefits. They're going to care whose name is on that deed. And, in the end, you might have to sell that house to pay back a Medicaid claim after someone dies. So you need to arrange your finances and your legal affairs and put things together in a way that's going to work when it comes to Medicaid. Again, something people don't know or understand. I can't fault them for doing things the way they do. Mom loans her son $10,000. Just by writing him a check. She doesn't have a loan agreement or anything like that. That's a disqualifying transfer. If son did pay the money back, maybe they'll cancel it out. But if son paid the money back $500 a month, is there a nice clean record of him paying back mom? There's the one check that was $10,000 went out to son. Where's the record of him paying it back? Record keeping is very important to the Medicaid office. They want to see everything on paper. And a lot of people and families do things off the cuff because that's how people do it. That's okay. That's the way we do stuff. But it's not okay when you're talking about asking the government to give you benefits. The last thing on my notes is myths and misconceptions. We talked about it already. Medicare does not pay for long-term care. Medicare only pays for medically necessary care. Doctors, hospitals, perhaps a short stay at a nursing facility for rehab. That is medical care. As long as it's medically necessary care, Medicare will pay for it. But long-term care, usually home health aides, assisted living, long-term nursing home care, it's not medical care and Medicare won't pay. I know, I always hear people say to me, I heard you could give $10,000 a year to each of your kids. You're allowed to do that. Well, yeah, you're allowed to give anything you want to anyone at any time. We do have a gift tax system in the United States, the gift and estate tax. The exemption is about $15 million. So probably none of us are subject to the federal gift or estate tax. There is no New Hampshire estate tax. The gift tax melds with the estate tax because you don't want a millionaire or a billionaire to be able to give away all their money a week before they die, and then the government doesn't get any tax revenue. So yes, there's a gift tax, but we've all got that $15 million exemption, and there's also a yearly exemption under the gift tax. It was $10,000 a year for many, many years. They've indexed it to inflation. It grows a little bit every year. It only goes up in $1,000 increments. This year it is $19,000. But it's not that you're allowed to give $19,000 to your kids. It's that if you do, it has no effect on the gift or estate tax. Again, if you're under $15 million, it doesn't matter one way or another. But if you had more than $15 million, you might be making yearly gifts to your children and grandchildren, and you'd stay under that $19,000 yearly limit. But for most people, that number doesn't mean anything. And that number is a tax number under the tax code. It has nothing to do with the Medicaid rules. There's no gift exemption under the Medicaid rules. Any dollar or two you give away is potentially a disqualifying transfer. Now, Medicaid doesn't look at every single dollar. They don't have the time or ability to look that big, that small. They only look at big transfers. But they do scrutinize everything that's more than $500. So when and if you're applying for Medicaid, they look at your checking account, they look at your bank statements. Anything more than $500, you better be able to explain it to them with a receipt, or maybe if it's electronic and it was to, the town for taxes, that's self-explanatory. You can't spend your money except for your care. No, you can spend your money on yourself any way you want. As I said that earlier. If you need care, pay for your care. If you want something, a new TV, a new car, you're free to buy it. It doesn't disqualify you from getting Medicaid if you spent the money on yourself.
Thousands of dollars over the past.
Yes, if you paid your children's debts, that's a disqualifying transfer. Now, what's that?
I said, that sucks.
For the kids, I guess, yeah. I mean, if the parent had signed the loan agreement, if the parent was also on the hook for that debt, paying back a debt is an allowable expenditure. If you owe the debt, you can pay it back. But if the parent's name wasn't on the loan and it's just the kid's loan, the parent paying it back is a disqualifying transfer if it happened within 5 years of applying for Medicaid. So it's very difficult. Yes, you cannot be willy-nilly dealing with your finances if Medicaid is looming out there in the next 3 or 4 years. And for everyone who's, of a certain age and a certain health situation and a certain amount of money, yes, it's out there somewhere. I mean, if you've got $10 million, you're probably never going on Medicaid, and you want to pay your kids' loans, you can. But if you're a regular person with a house and maybe some hundreds of thousands of savings, maybe even $1 million of savings, you might spend a bunch of that money. You might wind up in a nursing home. You might have to apply for Medicaid. If you're 85, 90, 95, yeah, it's out there pretty soon, so you better be thinking about it. Yes? Okay, so she said, can you pay a family member as a caregiver? You can. That's an allowed expenditure because you're paying for caregiving. It's a tricky thing, though, because any caregiver you hire is an employee, and if you're going to pay them, you need to pay them through a payroll system where income tax, Social Security, and Medicare are withheld. You got to have workers' compensation insurance to pay them. So you can't just willy-nilly hire a family member or a friend as a caregiver. You really need to be careful how you do it and do it within the rules, because you could get in trouble later on for tax fraud or mispaying taxes if you didn't pay them as an employee. What was the second half?
So if something is found in the look back, say you gave your daughter $10,000,
Okay.
other than waiting 5 years
Oh, okay.
to apply again, what would you do?
So there's the thing about the look back is that if you apply for Medicaid and they look back through the 5 years and they find a problem, well, there's no fixing it now. You've told Medicaid about it. How do you fix it? Well, I mean, there are fixes, but you usually cannot wait 5 more years. That's not going to work. Sometimes you can. I mean, sometimes if you did something big 4 years and 4 months ago, if somehow you can figure a way out to go 8, 9 more months and get past the 5-year look back, you can and should do that perhaps. If you've applied for Medicaid and they found a disqualifying transfer, there's 2 things that could happen. One is you are disqualified from Medicaid for a period of time based on what the dollar figure of the transfer is. You're not disqualified for 5 years. If you gave away $10,000, it's really only going to disqualify you for a few weeks. So maybe the family members just find the money to pay for those few weeks and get you beyond the disqualification period. Maybe the family member gives you back that $10,000 and you use it to pay the nursing home, and then again it gets you through the look back period and you're back on Medicaid, or you're on Medicaid. Curing the transfer, that's what we call when someone fixes it by giving the money back, or finding a way to make it through the disqualification period because other family members pay or something. I mean, the usually problem people run into is they gave their granddaughter $10,000 for the wedding, and then they're in the nursing home 3 years later. You can't ask the granddaughter to give you the $10,000 back. She doesn't have it. She spent it on her wedding. But maybe your kids can pony up the $10,000 and cure that disqualifying transfer. Other questions? Okay. Yeah, she's asking about if you can't afford a lawyer, what do you do? I did talk about some low-cost options. Most people do have some resources. She's talking about the house. That is a big resource for a lot of people. If they haven't given it away or transferred it to their kids, they can borrow against the house through a traditional mortgage, home equity line of credit, or a reverse mortgage. Sometimes, again, people come to me and they're asking, how do I protect my money? How do I protect things? And I say, why do you want to protect it? Who are you protecting it for? What's your point? What are you thinking about? And all they're thinking about is, oh, my money will disappear, and no one will get any value for that, and I really want my money to go to my kids. Well, sure, everyone wants their money to go to their kids if it's their kids or someone else, and that's their choice, yeah. But on the other hand, if you have some assets as you age, that's your money. You can do with it as you want, and maybe that money should be spent on your care. If you've got a house, maybe you should borrow against it and use that money for home health aides, or if you need to go to assisted living, maybe you should just sell your house and use that money for your assisted living. I mean, that's your choice. You may not want to do that, but I mean, if you're the elder and you're talking to your kids, a lot of the times my clients' children say, Mom and Dad, you don't need to save money for us. Spend it on yourself. That's okay. That's certainly allowed. You can do that. If there is a house, it is a source of value that can be used in many ways. I mean, a reverse mortgage is not a bad idea for some people. Reverse mortgages have a horrible, bad reputation. They were abused. There were financial advisors who were selling people on reverse mortgages and then taking the money out of their house and investing it in dubious investments and taking commissions all along the way, and it was a total scam. So reverse mortgages have a bad reputation, but they're a great way. Inherently, they're not bad. They're a great way to tap into a huge amount of money, which is the equity in your house. Now, I think the modern rules only allow you to borrow up to 50% of the equity of your house. But, that's a resource a lot of people might have that they could use for all sorts of things. Maybe it makes sense. Not every time, but sometimes it does make sense. If someone's got a lot of valuable real estate and not much cash, then a reverse mortgage might make sense.
What about Medicaid annuities?
I did not talk about Medicaid annuities. Okay, so we talked about the PPA, the patient paid amount. We talked about the MMMNA, the monthly minimum maintenance needs allowance of the spouse. The key issue here is that the income of the person who's in the nursing home does have to go to the nursing home, but the income of the one at home does not. It's her income, assuming she's the wife. So one of the ways to protect assets even at the last minute is to convert countable cash assets into an income stream for the spouse at home. This is allowed under the rules. It is one of those tricks that we hope they don't take away from us. It's not a trick. It's allowed within the rules. If the couple had $200,000 in a Fidelity brokerage account, then, the one in the nursing home doesn't qualify for Medicaid. They have too much money. The spouse at home could take that money and purchase an annuity with that money. It has to be done very carefully. The annuity has to be irrevocable, has to be actuarially sound, it has to be immediate. Actuarially sound means that, if you gave $200,000 to an annuity company and they're going to give you $500 a month for the next, I don't know what the math works out to be, 20 years or something, that would not be actuarially sound, because you're not going to get back your $200,000 if you're 80 years old. You're not going to get it back within your lifetime. It's going to go to your kids maybe, but you're not going to get it back, so you're making a gift. But if you got a $200,000 annuity and you're 80 and you have a 4-year life expectancy and you got a 3-year annuity, and whatever the math is, they're going to give you $5,000 a month for 3 years to give you back your $200,000. You haven't given anything away under the Medicaid rules. It's not a disqualifying transfer. And if it's the community spouse who's getting that income, she won't get any income of her husband in the nursing home because she's way above the MMMNA. But that $200,000 also doesn't disappear to the nursing home. The spouse at home can keep it. So it is a tool that can be used. It comes up a lot sometimes, but it depends on the situation whether it makes sense or not. Everyone's different. Everyone's financial situation is different. The trouble is, a lot of people have retirement funds, IRAs, that are hard to deal with. If it's the IRA of the spouse who went in the nursing home, sometimes you can annuitize it, sometimes you can't. If you take it out of the IRA status, you lose 1/3 of it to income tax right away. So you gotta, it's an individual tool that might work for some people, but not always.
You can also get a good lawyer.
There are all sorts of clever tricks or tools that we utilize that work within the rules. The Medicaid rules say that an investment property is a non-countable asset. So yes, if you had some rental property that brought you in income and your spouse went into the nursing home, they will not force you to sell that rental property. Would you go out and buy one at the moment that your spouse is about to head in the nursing home? Maybe, but it's not a tool. It's not something we suggest to people, but it's something you could do. I mean, if you were looking at an investment property, it is good to know that you won't lose it to the nursing home if your spouse does go in the nursing home. Something to think about, especially good if it's in the healthy spouse's name. But of course, people do not always die or in the right order. The other thing I heard this morning, talking about caregiving, is that they said self-care is very important for caregivers. I can't tell you how many clients I've had where, and it's usually the wife who's the caregiver and the husband's not well. She's working real hard to take care of him at home. And guess what? She drops dead of a heart attack. He's in a nursing home. Whatever planning we did for a couple doesn't work anymore because she went first and no one expected it, but it happens. Got to take care of yourself. I saw some other questions. Life insurance, if it has a cash value, is a countable asset. Any asset you have is a countable asset for Medicaid eligibility purposes. Seems simple. You got $50,000 in the bank? Sure, that's a countable asset. But you got this life insurance policy with a $100,000 death benefit, but it has a $50,000 cash value? Yes, it's a countable asset. The $50,000 cash value is a countable asset. Something we have to deal with sometimes for clients. Usually a couple options. You could just cash it in, take the $50,000 and spend it, or annuitize it perhaps. Sometimes you can borrow against the life insurance policy, drop the cash value down, do something like annuitize the borrowed money, and then at least you kept the $100,000 death benefit maybe. Shame to cash in a policy for half of its death benefit when the person who's probably going to die in the next few years. So, yeah, everything is a countable asset if it has a cash value. I've never heard of 6 burial plots being a disqualifying amount of assets. I guess 1 burial plot is okay. A lot of people bought family plots, but didn't he buy them years ago? So it wasn't a disqualifying transfer, but they counted it as an asset? Wow. Did you get a value of the asset from the cemetery? It was written on it? Well, then he has to sell it. So he finds someone to sell it to.
Correct.
But you put it on the open market. You say, how much will you pay for this burial plot next to Joe Smith and his mother? And if you can't sell it, well, then you can't sell it. I mean, if you could sell it, yes, you'd have to. And that's kind of ridiculous. I've never heard of that. But that's an example of DHS, I think, going overboard, but they do sometimes. I mean, their job is to protect the government money and not willy-nilly give it out. I have some sympathy for the DHHS workers because they're working. There's a lot of people out there trying to cheat the system, and they see it every day. They see the cheats, the welfare cheats that are out there trying to get something for nothing. They get to believe that everyone is a cheat, which they shouldn't, but I understand it. I think it's horrible when they treat an elderly person or their spouse as if they might be a welfare cheat when all they want is whatever they're entitled to, the nursing home paid through the Medicaid program if they're eligible. But yeah, DHHS is like that. They've seen the welfare cheats, the people trying to get away with something, who are lying or hiding something, and so they kind of suspect everyone is lying or hiding something. A lot of people are not intentionally hiding something, but they are wrong. They're making a mistake. They're failing to disclose something. It is DHHS caseworkers' job to ferret that stuff out and find it. I think burial plots is kind of ridiculous, but I mean, yeah, that's usually something that has no value. I mean, it doesn't have a real dollar value, but I guess, yes, it does. You could sell it. So, okay. Yes?
Would gold, Bitcoin, or silver be considered assets?
Absolutely. Anything that has value is a countable asset. People always say, oh, I got $50,000 in the safe at home in cash. And I say, well, it's a countable asset. Maybe no one knows it's there. So if you don't tell Medicaid, they won't know. But you're committing Medicaid fraud when you fail to tell them. You got a bunch of gold bullion in your safe at home, $50,000 worth, it's a countable asset. And if you don't tell Medicaid about it, you're committing a crime when you sign that Medicaid application that says, I'm disclosing everything. And maybe it's not you that's committing that crime, it's your child, your son or your daughter. Don't make your family commit a crime. If it's there, you have to disclose it or deal with it in some way. People always say that, I'll just take my money out of the bank and hide it. Yeah, no, it doesn't work.
So,
That's a tricky one. I'm not sure who owned the GoFundMe money, but if it was given to the person, I think if it was other people's money at some point in time, if it was used for the benefit of that person and they never got the cash, I don't think it's countable at all. But
If it's in there, if it's deposited in a bank account, and then it.
well, sure, if it went into their account in their name, well, that's where it came from. DHHS generally doesn't ask too much about income because they don't need to. You get Social Security every month, it shows up on your bank statement. You get a pension, it shows up on your bank statement. But yes, if you deposited $50,000 in your checking account one month, they're going to say, where the heck did that money come from? Because they want to know, is there something else out there? Do you have that rental real estate that you didn't tell us about? And those are a year's worth of rents because you got some other bank account that's in the name of some LLC that you didn't tell us about. They do want to know. If they see you, they'll look at your tax records too, your 1040, and they'll look for things that maybe you didn't otherwise report. So I don't know if you have to report the $50,000 from GoFundMe, whether that's a gift and doesn't count as income, or is it income and you have to report it? I don't know. But, I mean, it'll show up somehow. You can't hide stuff from DHHS. They're very smart. They know what they're doing. You can't and you should not hide anything from them. But within the rules, you can do certain legal things, and that's fine. Yes. It was a disqualifying transfer or an asset that had to be. Yeah, but mom's diamond ring that she got 40, 50 years ago when she got married, no. They're not taking away anyone's wedding ring or anything like that. But how do you go wrong? Yeah, you look at the rule, a non-lawyer looks at the rule and says, oh, personal jewelry is not countable. Let's go out and buy a $100,000 ring for mom. Well, guess what? It shows up somewhere in the 5-year look back that $100,000 was spent. What was it spent on? Oh, a ring for mom, then personal jewelry is not countable. No. The Medicaid office says, no, this one we're counting. It's not her wedding ring. It's not her engagement ring. It's not her pearl necklace she got on her 25th anniversary. You just bought it. You're trying to hide $100,000. No, they wouldn't let people get away with that. Let me tell you a couple things, a couple stories of mistakes people have made. Medicaid can be very strict. They read their rules and they follow them very strictly. You can be mad at them or agree with them because that's their job, but they're pretty strict. Sometimes it doesn't make sense. Maybe that funeral plot thing did because he shouldn't have bought 5. He should have just bought his 1 that he needed, or 2, him and his spouse. But there was a case where a child, mom was in the nursing home. She was allowed to keep the house. She went on Medicaid. Then they decided, well, we got to sell this house. But it needs some work. So the son put $200,000 in the house fixing it up. And then they sold the house, and he took his $200,000 back, and they made a good amount of that back because the sales price was higher. And then the proceeds were used to pay for mom's nursing home for another 2 or 3 years, but then they ran out. She went to go back on Medicaid, and Medicaid said, what's this $200,000 your mom gave away? He said, no, I put $200,000 in the house, and she paid me back. They said, well, show us the loan documents where mom agreed that was a loan. No, you gave your mom $200,000 by putting it into the house of your own free will with no expectation of paying it back because you didn't put it on paper in any way that it was a loan. And when mom gave you $200,000, that wasn't her paying back a loan. That was a disqualifying transfer. So you got to be very careful about how the rules work and do the right thing. If you're going to do some manipulating and dealing with Medicaid, you got to be very careful and do it cleanly and accurately. You can do a family loan, that's fine, but do it in writing. Have it paid back appropriately at the right time with the right dollar figures. That's the system, if you will, that we live with. Yes? If a parent was in a nursing home, I mean, if they were on Medicaid, then the nursing home got paid. Medicaid can seek a state recovery against a house if there's a house left over, but they can't go after the children. That's not what happens. Now, the nursing home industry was coming up short, and I have some sympathy for the nursing home industry. A lot of people go in a nursing home, they have some money, then it's gone, then they apply for Medicaid, then, oh, the family did some stuff that was wrong, and the person is disqualified from getting Medicaid. But, oh, there's no money to pay the nursing home, and they fight over it for 8 or 10 months, mom dies, and the nursing home just didn't get paid for that 8 or 10 months. That's pretty bad. We don't want that to happen because we don't want our nursing homes to go bankrupt on us. There was no solution for the nursing homes. They couldn't go after anyone. They wanted to go after someone. Yes, they got a change in the law. It's been 8 or 10 years now. The legislature changed the law. The law says that if there was a child who was like an agent under the power of attorney, or in some other way, they took charge of things, and they were supposed to do the Medicaid application, and they were supposed to fix things, and if they failed in that job, and by their failure the nursing home lost money, then yes, the nursing home can sue that child for their losses. Now they're going to have to prove that the child did something wrong. It's not that the child is just automatically responsible for the parent's debts, but if the child was in a position of responsibility and they did something wrong in that job, then yes, they could potentially be held liable. Long-term care insurance, I didn't even mention that. Yes, if you are young enough and healthy enough, I highly recommend looking into long-term care insurance. It's the money to care for you when you are older. You know, your elder care, your care when you're 80 or 90 is going to be $5,000, $10,000, $15,000, $20,000 a month. You will use your life savings to cover that. If you could buy some insurance privately to cover that, that's a great idea. Now, not right for everyone. It's a financial decision. You have to, hopefully you've got a financial advisor and an insurance advisor to help you make this decision. Long-term care insurance is frightfully expensive. It can cost, $4,000 or $5,000 a year. But $5,000 a year is not bad compared to $15,000 a month that you might be spending on the nursing home. So it's not a bad investment. You can pay $5,000 a year for your long-term care insurance and get $100,000 or $200,000 or $300,000 from the insurance company when you really need it. Maybe you can stay in a nice assisted living that Medicaid won't pay for because you got the money to cover it. Because you bought the long-term care insurance. But again, not right for everyone. It's going to cost a lot. So it's a tricky thing because you certainly don't want to be paying for your nursing home for 30 years in advance. You might spend as much money. You might have been better saving that money somewhere else instead of buying the insurance. But the younger you are and the healthier you are, the cheaper it's going to be. If you're sick, they won't sell it to you. If you've got any kind of medical condition that's likely to put you in a nursing home, they won't sell you the long-term care insurance. So you've got to buy it when you're young enough and healthy enough to buy it. But who can afford it? It is pretty expensive. I mean, I have it because I looked at the numbers and the whole situation. I said, yeah, it's a good deal for me. Now, it's gone up in cost over time. It used to cost me a couple thousand a year. Now it is costing me like $5,000 a year. But I'm going to keep it because I'm going to need it in another 10 or 15 years. I'll be very happy that I have it. My wife used to complain about it because she hated that bill because it looked like we're just throwing money away. Now her mother's in assisted living. Her mother sold her house. The money ran out in a couple of years. And now my wife says, oh, I see why we have that long-term care insurance. So when we need long-term care, we're going to get $8,000 or $9,000 a month from our long-term care insurance, $10,000 a month or something. That's pretty much enough to pay for assisted living. And the policies we bought, they don't sell anymore. Our policies go on forever. As long as we're alive, we're covered. So we could, now of course you could drop dead of a heart attack and you wasted all that premium dollars on the long-term care insurance. So it's a toss-up. Because of that, a lot of the insurance companies have come up with some new products. a lot of them have these hybrid long-term care insurance, which is a mixture of life insurance and long-term care. So there's a death benefit. If you don't use your long-term care benefits, there's a death benefit that goes to someone. That's much more palatable. I mean, as with most insurance, if you pay your premiums and nothing goes wrong, you don't get anything back. You pay your car insurance and you don't get in a car accident, they don't give you your money back. You pay your homeowner's insurance and your house doesn't burn down, they don't give you your money back. Same thing with traditional long-term care insurance. But the newer policies have a death benefit. So if you don't use the long-term care benefit, maybe there's 50 or 100,000 that go to your kids. So that's much more palatable for a lot of people. It has to be the right financial decision for you or your kids, whoever it is. Does it make sense for them? I mean, all these things need a lot of thinking about. And no, there's no book that tells you all this stuff. You just need to hear it from someone like me to learn it. You have another question.
It wasn't a question, it just.
Long-term care insurance was just nursing home insurance, so it only paid for nursing home care. Most modern long-term care insurance meets the broader standard of long-term care, and will give you money for home health aides or assisted living or nursing home care. You have to qualify for that. You talked earlier about that medical qualification for Medicaid. You got to medically qualify for your long-term care insurance benefits too. Sounds like you need an expert behind you to help you answer the questions properly about. Usually you need to have you require assistance with 2 out of the 5 activities of daily living, or you have cognitive deficits to a certain degree. And I don't know what those rules are, but a medical home health aide or nurse or something might know how to answer those questions in the right way. That was amazing. They talked about, does your mother need help with bathing? No. I just have to be in there with her and clue her to wash her here and there. Well, it sounds like she does need help with bathing. And so the answer to the question was, yes, Mom needs help with bathing. Boy, the world is a tricky place. You got to know little things like that. I don't know all those things either. We're all learning all the time. That's why we're at a meeting like this. I think I've gone way over my time, but I'm happy to be here.